Good evening. Welcome to tonight's virtual book talk. I'm Elizabeth Venditto for the Tenement Museum, and tonight I am joined by Ian Rosenberg, author of The Fight for Free Speech, 10 Cases That Define Our First Amendment Freedom. Welcome to the museum.
Thank you.
So tonight we're going to have our usual hour-long discussion of your book. You have 10 cases. We're not going to get to all of them, but I do encourage everyone as we go, put your questions in the chat. If we don't have time or we haven't talked about some of the questions, we'll get to them at the end. We're also going to have a link to buy the book. So by way of introduction, Ian Rosenberg has more than 20 years of experience as a media lawyer, and he's worked as a legal counsel for ABC News since 2003. He graduated magna cum laude from Cornell Law School and teaches media law at Brooklyn College. He's also an Emmy-nominated documentary filmmaker. Exciting for us is you're our neighbor on the Lower East Side.
Yes.
To live nearby with your wife, Carolyn Lasco, and your kids. And you have a personal connection to the museum. So I have to start off by asking you about this connection.
Yes, so my wife's family had their great-grandfather, my wife's great-grandfather, Harold Nachmanson. He came from Romania with his brother, and en route to Chicago, they stayed in the building of the Tenement Museum. And when the Tenement Museum first opened, you could see their name on the ledger. So we are intimately tied to the Tenement Museum and its wonderful programs, besides being Lower East Side residents.
Always love a connection in 87 Orchard Street. And we'll talk more about the Lower East Side in just a minute in your first case, but I just want to start off with an overview of the book and your writing process.
Yeah, well, so this book is designed to be a user's guide to understanding our free speech freedoms today. And each chapter begins with a contemporary question and controversy, from Colin Kaepernick taking a knee to National School Walkout Day to can Trump could he have stopped Stormy Daniels from speaking on 60 Minutes? And then it answers those questions by going into depth to tell the historical story of people who fought for a particular speech right all the way up to the Supreme Court, and how that decision then defines the rights in that area today. And I think taken together, it's a really effective crash course in understanding our rights, and also learning about the incredible stories of the real people, mostly regular people, not necessarily presidents or the New York Times, but everyday people who really felt a need to insist on one of their free speech rights, sometimes creating new ones. And so putting those together as a media lawyer at ABC News and teaching to communications graduate students at Brooklyn College, I've really spent my whole career explaining these concepts to smart people who aren't lawyers. So that is what this book is for, people who care about history and who care about learning about what history means for our rights today.
And it is a very smart book with incredible stories. But before we get to some, I want to talk about just the First Amendment itself.
Yeah.
Let's just get on the same page with what the First Amendment protects, allows, and restricts.
So the short answer is read the book, but the longer answer is that, I think one of the good places to start, and I try and weave this throughout the book, but one of the good places to start is with the text of the amendment. I am not a textualist. I believe in the Constitution as a living document, as Thurgood Marshall, Justice Marshall, and others have espoused. But if you start with the text, it says that Congress shall make no law abridging the freedom of speech. And that has been interpreted to mean both the federal government as well as the state government, as incorporated through the 14th Amendment, and certain state or federal actors, often public schools or public school administrators for public universities or high schools. Those can be state actors as well. So the bulk of our rights relate to sort of freedom from government action to restrict our speech rights. So that's sort of one overarching concept. Another is that freedom of speech does not mean freedom from consequences. And I think the stories that I tell, often people sort of say, like, I have a free speech right. And then they think, and they might, but that doesn't mean then that people can't object or seek to punish them or challenge them in some other way. And in these stories I tell, most of the protagonists who fought for their speech rights really faced a lot of consequences. Even when their rights were ultimately vindicated by the court, sometimes they lost their job, sometimes they were criminally prosecuted, sometimes they just faced, really community outrage and threats. So I would say, sort of freedom from government interference is a key concept, as well as not being free from the consequences of our speech is another overarching theme.
And these cases really help bring out the nuances in both of those situations, as well as, because their stories, the personal consequences. So I want to start back on the Lower East Side. You have an extraordinary story of a young woman, a young activist named Molly Steimer. And I'd love to hear about how she helped spark what you call a First Amendment revolution.
Yeah, so Molly Steimer, I think, is a relatively undersung feminist hero. She came to this country at 16, fleeing, Russian pogroms and anti-Semitic violence. She started working as a garment worker on the Lower East Side, and she was supporting her family, or helping to support her parents and her siblings. And it was a hard life. I think we sometimes, the Tenement Museum, I think, really shows that, but I think a lot of times we glamorize the life of immigrants, and it radicalized her, and she became an anarchist, and with a bunch of fellow anarchists lived up in Harlem, and wrote, among other activities, they wrote some anti-war pamphlets, anti-World War I pamphlets, particularly condemning Wilson's plan at that time to have American forces intervene in what was going on with the Russian Revolution, ostensibly to protect Czechoslovakia and some of the other allies, but many people thought really to thwart the Bolsheviks. And the anarchists were on the side of the Russian Revolution. And so Molly Steimer and her friends wrote two pamphlets, one in English and one in Yiddish. And they were both condemning the war, and the Yiddish one was more aggressively calling for a strike among munitions workers. And so Molly took these pamphlets, she was one of the lead distributors, and she threw them literally from the rooftops and out of bathroom windows on the Lower East Side, on Rivington Street, on East Broadway, where I live, and on Clinton Street. We have the records of this. And these people, even the pamphlets that people couldn't read, incensed people. It made front page news. And they were, the police came after them and caught them, and they were jailed for basically violating the Espionage Act, and sentenced in a trial that was rife with anti-Semitism. A judge in the federal court had come from the South, Delmar Clinton, I think is his name, and really anti-misogynist, racist, anti-Semitic. When one of her fellow defendants said, was referring to the founding fathers of this country as our forefathers, the judge indignantly responded, "You don't mean to say that those are our forefathers of this country? George Washington are your forefathers as an immigrant anarchist, do you?" Molly Steimer was also the subject of much of his very negative commentary. She refused to stand up, however, every time he entered the room. She became a sensation during the trial, but they were convicted. She was sentenced to 15 years, and the men were sentenced to 20 years, essentially for criticizing the government. And their case goes up to the Supreme Court, and they lose. The Supreme Court upheld their convictions, except Justice Holmes, joined by his friend Justice Brandeis, dissented. And in that dissent, that is where the revolution came from. Holmes introduces the concept of the marketplace of ideas, and basically says the best test of truth is the power of an idea to get itself accepted in the marketplace. Now, there are a lot of problems with the marketplace of ideas metaphor, and we can talk about those in a minute. But at the time, he really positioned dissenting speech as at the center, not at the periphery of free speech protection. And until, this was in 1919, and until then, there was essentially, even though we had a First Amendment, there was essentially no significant free speech decisions. And this, even though it was a dissent, changed the course of free speech history, but didn't do much for Molly initially. She was still in jail with the separate jails from her fellow defendants. And her very hardworking lawyer ended up getting them not pardoned, but deported as a way to get them out of jail, deported to Russia. And as she left the dock in Brooklyn, the SS Lusitania, I think it was called, that was departing, she said to her friends and family who had gathered, who she would never be able to see again, never let back in this country, she said, I hope that America is more free in the future than it is today. And it is now today more free because of the actions of Molly Steimer and her fellow defendants. So I do think it's an incredible story of how one young woman and her friends really transformed American law.
It is. And I want to follow up on that marketplace of ideas concept, because that is something that comes up throughout the book. Could you tell us more about it and how that really comes to play in this dissent?
So Holmes, really wisely says that he recognizes the power of speech, and he recognizes that speech is dangerous, and goes on to say that if speech wasn't dangerous, no one would care about it, and we wouldn't try and restrict it, but that instead, one student of mine once suggested that perhaps using an economic metaphor as a way of seeming less radical to defend these radical anarchists who are against, in favor of communal property and certainly against our capitalist system. So I don't think Molly would have liked the metaphor, but he says that it was basically like a market in what they used to call the ghettos around the Lower East Side, that people were selling things and shouting, and it was raucous, and some people might be lying at their stall, and some people might be offering you a better deal, and that you were supposed to sort of pick and choose from the truth, and that the government, again, this is lack of government interference, that the government shouldn't interfere in that marketplace. You should be able to hear everything, even crazy anarchist notions, even theories and beliefs that we or people might not disagree with, and that was the best way to get truth to sort of prevail. He also, and this is the less famous part of what he said, he also said that it's an experiment, as all life is an experiment, which I love. So it's not necessarily that this is going to work to bring about truth in all circumstances. It's just it's the best sort of experimental model we have. Now, the problems with the marketplace. And there's a substantial body of academic critique, which is very significant, that I briefly discuss in the book, and in the endnotes, there's a lot of references if people want to pursue it further. But Catherine McKinnon is a feminist legal pioneer, has said, to paraphrase her, has the speech of Nazis ever made the speech of Jews richer? Has the speech of the Ku Klux Klan ever made the speech of Black people more fulsome? Have the so-called, she said, speech of pornographers helped women? No. She argues. And so that is one critique. Another critique is who is led into the market. Critical race theorists and others have correctly pointed out that Black people have been discriminated in so many ways systemically, but also have been excluded from most markets, theoretical or real. Women certainly have been excluded from those markets, as well as the economically disadvantaged. If you have less money to spend on speech, does that mean your speech gets less power? So these are all really significant and very persuasive criticisms of the marketplace of ideas. However, it is a bedrock principle to this day, even in the decisions I talk about at the end of the book, and we sweep from 1919 to 2017 in the 10 cases I cover. Even in 2017 and even today, the court still uses the marketplace notion as central to its conception of speech. So even if you disagree with it, you have to understand it to be able to critique.
And we will come back to the marketplace of ideas throughout this talk. Again, I also encourage the audience, if you have questions about this or anything else we're talking about, please add them in the comments and we'll talk about them a little bit later. I want to shift gears to two other cases that are not as well known, and talk now about the right not to speak. Again, having young people, now much younger, at the center of it. So you write about two cases in the 1930s and 1940s. So as we're approaching a different wartime, Jehovah's Witnesses were involved in two very high profile cases about children refusing to say the Pledge of Allegiance in public schools. So I want to talk about these two cases and the issues that were at stake.
Yeah, well, so I didn't know a lot about these people before I was doing the research for the book, although I knew about the case. So I begin this chapter talking about Colin Kaepernick and his take a knee revolution, his take a knee movement, and I say although the court hasn't addressed whether there is a right not to a right not to say the stand for the national anthem, they have twice addressed the issue of whether you can refuse to say the Pledge of Allegiance to the flag. So that's the contemporary jumping off point. And then we go into the two cases you talk about. The Gobitis children were a 10-year-old and 12-year-old brother and sister, and they refused to say the Pledge of Allegiance in school, in their, what we would say today would be sort of a middle school age classroom. And they did it because the leader of the Jehovah's Witnesses at the time had said that to pledge to the flag was a form of idolatry that violated their religious beliefs. And the school board, so they refused. The school board tried to suspend them. Initially, the attorney general of the state said that they would have to be a school board resolution to require the pledge. It was just informal at that point. Gobitis wrote this William Gobitis wrote this charming letter that it's in the National Archives. You can see as sort of crossouts, talking about how he does not just respect the flag, it's just that it violates his religious beliefs to pledge allegiance to it. The school board turned a cold shoulder to him, and they really suffered, again, a lot of consequences. They were not allowed to be what we would call homeschooled today. They were threatened to be put in juvenile detention. If that happened, they had to travel to another farm with other Jehovah's Witnesses where they had to sleep over because the roads weren't good enough to get home every night in order to not be imprisoned and for their parents to not be imprisoned. And the case goes up to the Supreme Court, and Justice Frankfurter, who one would think had a perfect liberal pedigree, he was a co-founder of the ACLU, had defended Sacco and Vanzetti, the anarchists. He was a real, grew up as an immigrant, not knowing English on the Lower East Side, one of the first Jewish professors, the first Jewish professor at Harvard Law, second Jewish justice. And yet, this was right as the Nazis were invading France that this decision came down. And basically, Frankfurter says that in the balance between unity and liberty, that unity was more important during wartime. So what happens is that it sparked the biggest wave of religious violence in this country, many people think ever in American history. There was sort of, as the Gobitis has said, there was sort of open season on Jehovah's Witnesses. People were tarred and feathered. They were run out of town. One man was castrated. This was all across the country. And thousands of students were threatened with jail. And in just 3 years, the court is realizing what a mistake they have made. So one of the other themes that I am talking about is the evolving process of how sort of constitutional law can change and how generally the court respects precedent, meaning past decisions. But in this case, they wanted to overturn the principle of stare decisis, that basically that's Latin for, as things stand, so sort of keeping the cases, that follow past cases. But they broke free from that tradition. A new set of two other siblings, Marie and Gathy Barnett, they again refused to pledge allegiance. They were in such a small town that initially they didn't even have a flag. They had a picture of a flag, and then they refused to pledge to that. And then they brought in a flag to see if they would actually stand up. They were taunted and called slurs because now the war was underway. And it gets up to the Supreme Court again, and this time Justice Jackson has a really beautiful, stirring decision. And now they are in the majority with Frankfurter in the minority, and he acknowledges for the first time that there is a right not to speak, that the government can't compel you to express a message that you don't believe in. And he says, to paraphrase again, that if there's any sort of fixed star in our constitutional firmament, it's that there's nothing in the constitutional constellation, that there's nothing that should be orthodox in politics. In other words, there should be no government mandating of a way to believe or a way to behave. And he sort of reframes it. He says that this is not a religious minority seeking an exception. He is saying that there is a right not to speak. They are not seeking an exception. They are being persecuted and having their rights infringed on by the school board. And so that was a very significant twist. So what does that mean for Kaepernick? I then say at the end, and I'll just talk about quickly, Kaepernick was employed by the NFL. And another theme in the book is that private employers, because they are not the government, can generally restrict our speech rights. So the NFL could restrict his speech rights, but should they? If the Barnett decision means anything, it means that that dissent is patriotic and that people should have a right not to speak. But also it's important, again, for students. If you are a student at a public high school or a public university and you choose to take a knee or protest in some other way by not speaking, the equivalent of the government, your school administrators, cannot punish you for that choice because of the Barnett decision. So students are actually more protected than Colin Kaepernick would be, thanks to the fellow students, the Jehovah's Witnesses students during World War II of the past.
And that's a really important distinction. And I want to go back to the Barnett decision. It's very curious. And we have this big reversal in a really short period of time, still during wartime, from unity is the priority to the right not to speak and dissent is patriotic. So what explains that shift?
Well, I think it was a lot of outside factors, not law. And another sort of theme of the book is how much facts matter and sort of how much the world situation matters. When we talk about the Vietnam War protests or the civil rights protests, a lot of what the court is thinking about is not the briefs that are before them, but what's going on in the world. And I think that's a realistic way to look at these cases, which also sometimes goes under-recognized. Two of the things that were important were that now we were officially in the war and we are fighting the fascists and we are fighting Nazis and we are actually fighting for religious freedom and free speech freedom. And there had been a case in Nazi Germany where Jehovah's Witnesses were persecuted under similar circumstances. And this was widely written about, that, this Supreme Court, the Gobitis decision, Justice Frankfurter's opinion, is very similar to the opinions of Nazi Germany. And isn't that a shame, to use the Yiddish, isn't that a shanda on this country, that we are not distinguishing ourselves from the very people that we are fighting? That's one thing. Another thing is that there was a very disturbing connection between the Pledge of Allegiance and the Nazi salute. The initial pledge was like this: you sort of put your hand up, like a Nazi salute, except that you had your palm open. So in between the Gobitis decision and the Barnett decision, the Congress said, no, this over your heart is now the proper way to salute, purely just to avoid comparisons with the Nazi salute. And I think that also had some influence. That, look at how visually we are very much in step with fascism if we metaphorically force people to participate in a pledge that they don't want to be part of. So I think it was these outside factors, as much of on top of the religious violence that had followed the decision, that really ended up shifting the balance.
Now I've got to ask you about another case, because there's another powerful decision involving youth in public school and anti-war protest. You talk about the case of a group of public school students in Iowa during the Vietnam War and black armbands that they were wearing to class. So let's talk about that one.
Yeah, so Mary Beth Tinker, another middle school heroine, she decides with some of her friends that she is going to protest the Vietnam War. And this is the relatively early days of America's involvement. The war was still very popular among a majority of Americans. They supported the war, particularly in the Midwest at that time. And she wears a black armband, she says, to mourn the dead on both sides, which is a very radical notion that she was also mourning the Vietnamese casualties. And she was inspired by Robert Kennedy at the time, had advocated for a Christmas truce. And she wears this black armband to school. Some people tease her, but nothing goes too badly. And then Mr. Moberly, her favorite teacher, her math teacher, I love that name, he just gives her a pink slip and she makes her go to the principal's office, and they tell her to take off the armband or she'll be suspended. And she has said that in a burst of courage, she quickly took off the armband. And she uses this later. She talks about how you don't have to be brave every moment. You can just be brave for some moments, and you don't worry if you're not brave in every moment. So she sort of regrets that she does that. They suspend her anyway. Another friend of hers in high school does the same thing. He's suspended. Her brother wears it the next day. He's suspended. And school board upholds their suspension. So represented by the Iowa Civil Liberties Union and a lawyer who was like 2 years out of law school, represents them. They wear black to school. They don't wear the black armbands anymore, but they wear black clothing, which today wouldn't be noticed, but at the time was another radical move. The case goes up to the Supreme Court, and in a beautiful decision, just really elegantly worded, Justice Fortas says that students don't lose their constitutional rights as they pass through the schoolhouse gates. In other words, that students have a free speech right, not only that is essentially equivalent to adults, but also even in the school building. Now, there are limits. I begin this chapter by talking about the National School Walkout Day and the activists for March for Our Lives and others, and what are the rights that students have. So the Tinker decision says that basically the school administrators can't just worry that there might be some type of disruption. They need to have sort of a reasonable belief based on evidence that there would be a substantial disruption to the school practice, to the school day by the acts of civil disobedience or protest. So what that means is that you definitely have a right, students definitely have a right to sort of non-speaking wearing of armbands or buttons. But leaving the school during the day, that would be disruptive, and you could be punished for that. But students can't be punished more severely for leaving for a protest than they could to leave to go to the mall. In other words, there can't be viewpoint discrimination. So the politics of your act to leave are unpopular, perhaps in your community. So once again, students are not only at the forefront of protest, they are at the forefront of changing the First Amendment rights for so many of us.
And that was something I brought up with you earlier. I'm really struck reading several of these cases that it's young people, it's not just students, but young people in general who are so often the flashpoints for these questions about free speech, even though the three cases we've talked about, they're all wartime, interestingly. They're all very different political, religious contexts. Any thoughts about why young people keep coming to the forefront in some of these stories?
Well, I mean, I think it's because, it's a really good question, and I haven't put my finger on it, but I will say that I think it's because speech is such a powerful part of being a teenager. If I can look back, sort of articulating your views and sort of defining yourself with your speech, how you speak to adults, how you speak to your teachers, and how you start, for many of these First Amendment pioneers, how they're sort of defining themselves in contrast to the prevailing norms. This was a radical concept. There's a good book from NYU Press, my publisher, called Troublemakers, where it's sort of a history of student activism, particularly in the 60s. And she writes about how it was still, even with the civil rights movement and the sit-in protests, which were all led by students, that it was the idea that teenagers would have sort of valuable contribution to society was very radical then. And I think that that sort of radicalism carries over today. You know, we have Greta Thunberg and the climate strikes for change. I do believe that students will continue to be at the forefront of our speech activism, and very likely, as the speech rights change and evolve with future Supreme Court decisions, there will be students once again at the fore. There's a troubling case coming down the pike where involves Snapchat and a cheerleader in high school who used Snapchat to curse out her cheerleading team when she didn't make the team. And this is called Mahoney School District. And the court is going to revisit her outside of classroom, nonviolent weekend speech rights, which seems like it's going to turn Tinker on its head. But to understand what's going to happen with that Supreme Court decision, we have to look back to Tinker. And I think my chapter on that will give everyone the grounding that they need to understand that important decision that's coming down this year, probably.
And if you have more questions on Tinker, again, feel free to put them in the chat, or questions about students, free speech, public schools. But I want to shift gears a little bit, because a very important area of questioning when we talk about free speech is the press. And you talk about some significant cases, some more well known than others. But I wanted to start with a case you write about when the New York Times is sued for libel during the civil rights era, because it's a fascinating case.
Yeah, so this is New York Times versus Sullivan, which some people know. It's the case that gives rise to the actual malice test, which is very misunderstood, but it's the foundation of modern libel law. And I begin with Trump saying, Trump, the candidate, was saying, when I get elected, oh boy, are we going to change the libel law, because we're going to stop the press from lying and getting away with it. And that's Justice Thomas has a somewhat more sophisticated criticism of this, of our current libel laws as well. He says it's sort of created out of whole cloth. It's not part of the text. And so I talk about whether, and one of the motivating factors behind writing this book is that the demonization of the press over the last 4 years is, I think, one of the greatest threats to not only free speech and free press, but also to our democracy. And you know, President Biden has said that democracy is fragile, and I absolutely believe that. And so I want to shore up people's understanding of what a free press can do and what their rights are. So the case of Sullivan involves an ad that was taken out to support Dr. King and the student sit-in protesters. And it was Harry Belafonte and others in New York took out this ad in the Times. And it paid tribute to Dr. King, and it had a few minor inaccuracies. The number of times that King was arrested, whether it was a padlock on a door at a particular protest, and a number of Southern leaders, including one named Sullivan, who was essentially a police chief, sue, even though they're not named in the ad. They sue for libel. They win $500,000, $1 million judgments. And also, they sue not only the New York Times, but they sue the civil rights leaders, Dr. King in one case, Reverend Abernathy, Lowry, and others, you know, and actually seize their property, and in a segregated courtroom with a racist judge. And this case goes up to the Supreme Court, and the Times is worried that they are going to become bankrupted, and the personal fortunes of these civil rights leaders were also at stake. But the Times realizes that this case wasn't about vindicating reputation, because the people who sued were all rabid segregationists, racists, had made their careers fighting the civil rights movement. So even if they were criticized directly in this ad, that wouldn't harm their reputations in their communities. It would have bolstered them. But they were suing because they wanted to stop the East Coast press from covering the civil rights movement. And the newspapers in the South, after these libel victories, said that we have a club that we can wield now against outside agitators, basically. And the case comes to the Supreme Court, and Justice Brennan crafts the actual malice test, creates a unanimous decision that says that that you can criticize public officials. It gets later applied to other people, but that you can criticize public officials, the media can, and make mistakes. However, you can't engage in knowing falsehoods or reckless disregard for the truth. In other words, you can't lie and you can't turn a blind eye to the truth. And Brennan particularly specifically did not give the press blanket immunity, did not give them sort of carte blanche that actually Justice Black and some others on the court wanted them to. He worried about McCarthyism. He worried about how in just then the recent past, people did lie and ruin careers and lives. And so he creates this balance, basically a balancing test that gives preference to the press, but does not give them blanket immunity. So you can't lie, that is false. The press can't lie. They can make little mistakes, but they can't turn a blind eye to the truth. So that's the standard we have. That is why the press is protected, but not allowed to run rampant. And we really have the protest movement of this and the civil rights defendants, including Dr. King, to thank for all of our freedoms. And their sort of role in protecting the press is often undervalued. And I try and go into that in some depth.
You do in the book, you talk about it's undervalued at the same time with this case, they almost get pushed to the side. It's become the segregationists, it becomes for this classic white institution in the New York Times, and yet the whole controversy is over this ad speaking to the civil rights movement.
Yeah, there's a famous philosopher who said that the Sullivan Decision was an occasion for dancing in the streets, and I do think it's a wonderful decision. But I also don't want to oversell the victory, as you're pointing out, of sort of the all-white Supreme Court deciding in favor of the then all-white New York Times, where the underlying systematic discrimination of Black people in the South is put aside. Now, I believe that the court was doing that, and even Dr. King's lawyer didn't argue the civil rights elements. The other minister defendants, their lawyer did. But Dr. King's lawyer called it a matter of strategic realism. So they were keeping their eyes on the prize and were trying to make sure that the civil rights movement got coverage besides protect these minister defendants. But it is another way in which sometimes the world events are front and center, and sometimes they're really hidden in the background. Here, our national events, even though the racism of the South was so, and the segregated system was so prevalent in the subtext of the decision, it is rarely mentioned in the actual decision. And that's what I'm trying to unpack a little bit and bring more to light.
Lots of consequences.
Yeah.
Also, though, I should mention that there were severe financial consequences potentially for the New York Times should this judgment be against them. So.
Right. They would have, it was the general counsel of the New York Times said that he was never more worried in his career that the Times would go under. And there were also, it was not just the Times, there were millions of dollars of lawsuits in their book, The Race Beat, which is about the journalists covering the civil rights movement. They talk about how there were multi-million-dollar judgments against television, newspapers all across the South. Southern actors were deciding, several governmental officials were deciding, this is a way we can get retribution against the negative press we're getting. And the Times did stop covering the civil rights movement to an extent. They no longer had, this was an Alabama case, and they no longer had reporters on the ground in Alabama during the time of the trial because they were afraid. And the Sullivan decision did change that. So it had real on the ground consequences.
And go a little bit farther into, or closer to the present, also talking about the New York Times, to shift gears to a very famous case. You spend a chapter talking about the Pentagon Papers. Yeah. So here, the press again, but also now we're taking up again the question of national security.
Yeah, so the Pentagon Papers, today it might seem somewhat inevitable that we have leakers and they release documents and the press is allowed to publish those, but that was not the case at the time. In fact, it was such a, again, radical notion that the New York Times' lawyers, when they received the Pentagon Papers from Daniel Ellsberg and were preparing to publish them, their lawyers ditched them. The firm Lord, Day and Lord, which of course sounds like the kind of very white shoe firm that it was, abandoned them because they said, you can go to jail. You, the publisher, can go to jail for this. We are not going to support you in publishing these documents. But the Times does go forward I think one of the things that is really exciting about the decision is what happened right before in arguing the decision. Professor Bickel, joined by Floyd Abrams, was asked, so are you arguing that even if it would mean 100 lives lost for publishing these papers, that the New York Times has a right to do it? And the lawyer tried to dodge it by saying, well, none of these papers that have been published by the Times would actually cause any imminent harm. It's mostly a historical document. And the justices keep focusing him on that point. And he ultimately says, no, my humanity says that we must bow to the immediate and direct loss of life would prevent publishing the papers. It was a very smart move, even though the ACLU at the time wrote a brief the next day denouncing that decision. And Justice Black said it's a pity that the Times couldn't find a lawyer who cared about free speech. But it was a very smart move. That got him the swing votes he needed in a mixed decision to say that there is a right to publish even top secret national security documents during wartime, because that our battles are not won just on the battlefield. They are often won here at home. And if we don't have the ability, the press doesn't have the ability to criticize the government's actions, which the Pentagon Papers proved that the government had been lying to the American people about over and over again about the war. If we don't have those protections, we will lose what's really at stake in any wars that we fight. And so basically, in all circumstances, unless there is direct, imminent, significant harm to the country, there is no ability to stop the presses. That is an unconstitutional prior restraint. But going back to what we said about consequences, Daniel Ellsberg there was a majority of members of the court who said, although the Times has a right to publish these, the government also has a right to prosecute you for national security violations, for basically Espionage Act violations of leaking these documents. And Ellsberg was being criminally charged and prosecuted. And it was only because Nixon's break-in of Ellsberg's psychiatrist's office and then Watergate revealed Nixon's dirty dealings and the plumber's dirty dealings in trying to get Ellsberg, that his case was dismissed. Basically, the judge was so sort of disgusted by what the government had been involved with. He said that the whole case was dismissed, and then the Nixon administration collapsed. And so they weren't able to re-prosecute him. But it is another example that freedom of speech to publish materials does not mean that you are protected from consequences.
Significant connection to the present as well. You want to talk quickly about how you draw that to the present?
Well, sure. So, I mean, I talk about, can Stormy Daniels, when I wrote the book, I was saying, could Stormy Daniels have, who, was the adult film star who allegedly had an affair with Trump, and then Trump's lawyer, Cohen, had paid her off with a non-disclosure agreement before the election. And when she announced that she was going to be on 60 Minutes, there was initially excitement about what was she going to say. And then there was a question about whether she was going to be able to say it. And was the Trump administration or Trump himself going to try and stop her from speaking? And he did in sort of complicated ways. But she knew that she had the Pentagon Papers on her side to act as a sword and a shield, to sort of bring, to protect her and to protect the 60 Minutes from publishing the interview. And that's the sort of the shield and a sword to sort of move forward with what she wanted to say, and to know that she had a tool to do it. The Pentagon Papers decision became her tool. Now, at the last minute, as the book was going to press, we actually had Trump explicitly try and stop the media. And so I do have a couple lines about how he tried to stop the Bolton book that criticized him, his administration, and how his brother-in-law tried to stop Mary Trump's book that criticized him. And in both cases, the Pentagon Papers is the deciding factor of how they were not able to stop the press or publication based on their claims of basically contract limitations, because again, if you can publish top secret documents during wartime, you can certainly, which were illegally leaked and illegally taken, you can certainly violate contract principles to have a tell-all book.
So the Pentagon Papers having an impact of free speech law beyond national security, which we often associate with national security, but lots of ways up to the present. I want to take a side note to the comments. We're getting some reaction to restrictions on student speech and a feeling that students often have severely restricted speech, cannot refuse to pledge despite the law, cannot wear buttons or put stickers on cars. That's a good segue to another case that you talk about also during the era of the Vietnam War, not student, but talking about offensive speech in protesting. It was a case I wasn't familiar with, but has really interesting implications for First Amendment protections for offensive speech.
Right. Well, so I begin this chapter by talking about the woman who flipped the bird at Trump's motorcade, and is there sort of a right? And then somebody took a picture of her doing it, and it went viral, and she lost her job. And I say, is there a right to offend? And there is, and it dates back to this great case called Cohen versus California, and a Vietnam War protester. I mean, it's not clear how much he was protesting, but he had a jacket. He was actually appearing in court as a defense witness, and he was wearing a jean jacket that had written on the back, I'm going to use the curse word, fuck the draft. And the judge gets a note from the police officers who don't like that. He took the jacket off as he sat in the courtroom. And the judge said, he doesn't have it on. I'm not going to charge him for contempt. But the police really didn't like it. When he put the jacket back on as he walked out of the courtroom, they arrested him for disturbing the peace. There was a 30-day jail sentence. He fights it all the way up to the Supreme Court. And in another extremely famous phrase, the court says that there is a right to offend, and one man's vulgarity is another man's lyric. And in other words, we cannot restrict certain words, because words have emotive power that are just as important as the actual message that they are conveying. Or the emotion behind the message is just important as the message itself. Because like at the oral argument, people said, what if somebody had written, I dislike the draft? Well, first of all, that's not what they're trying to say. That's not conveying their message effectively, but that wouldn't have been offensive. So they were trying to regulate a word, not conduct. So at the end of the book, most of the book is descriptive rather than proscriptive or prescriptive, but at the end of the book, I have some maxims about sort of free speech principles to hold close to your heart that I would advocate help future decisions. And one of them is that there is a right to offend. And another is that we should let speakers express their message how they choose. And Cohen is really the fundamental case supporting that right. I do have one thought about that comment that came in from the students, if you want me to address.
Yeah, go for it.
People often say, and I think that was particularly perhaps in the school context, that like, yeah, I know that I have some theoretical rights, or maybe there's even some case I've read about that says I have these rights, but what does that mean for me for real? And in the afterword, another thing I talk about is George Orwell, after World War II, had said that if we don't know about our rights and we don't care about our rights, it doesn't matter if technically we have them. That if people care about free speech rights will be protected. And if people forget about free speech, the rights, particularly the rights of minorities, will be trampled on. So that's one of the key reasons I wrote this book, is not only so that people know what their rights are, but people can advocate for change as a grassroots activity wherever they may be. And I use Supreme Court cases because they're a clear way of distilling the law, and it's another way of sort of talking about the meaning of our country. But most cases don't go to the Supreme Court. Free speech issues happen on the ground every day. And I hope that this book gives people more of the tools they need to advocate for change or to inform people in authority about the wrong things that they may be doing to restrict speech. So I'm very aware that these rights, in theory, sometimes don't get put forth in practice, and I hope they do more often.
I do want to make sure we talk about one particular case before we wrap. We have some time, so please keep giving us questions in the chat. But you have a chapter talking about a protest from the Westboro Baptist Church. So when we talk about, one man's vulgarity is another's lyrics, and we talk about free speech as a bulwark against the government, as expressing political beliefs, I think it's very easy for most of us, at least in 100 years after some of these cases are decided, or 50 years, to be more comfortable with that. But this is a tremendously difficult case. And as you talk about the case, for the family involved, I'll let you tell the story, but even for the justices deciding the case, this is a difficult one. I'll let you tell that story.
And even, as a stalwart believer in free speech, I begin this chapter talking about the Nazis marching and neo-Nazis marching in Charlottesville, and hearing the chants of Jews will not replace us. It was one of the most disturbing examples of hate speech that I have heard about. And so that people will often say, well, hate speech, free speech doesn't include hate speech. And that is not legally correct. And so I tell the story of the Westboro Baptist Church, which is the Supreme Court's most recent in the 2000s, look at hate speech. And it involves the hateful Westboro Baptist Church, who mostly was just one family, and they would, among other things, they would protest outside of military funerals. And they believed that military deaths, particularly in Iraq and Afghanistan, were the result of God's punishment for America's, in their view, over tolerance, too great of respect for gay rights. And I won't say what some of their sign says, because they're so abhorrent, but they did say things like, God loves dead soldiers. And they protested outside of the funeral of a very young man, Matthew Snyder, and his father sued the Westboro Baptist Church. They were protesting on the public land outside of the church, where the Catholic church where he was being buried. His father didn't see them because the limo driver was very savvy and drove him to a back entrance. But he heard it that night on the news, and it turns out, this is not in the court record, but it turns out that the father was gay, and his son was not, and his family knew, but nobody else knew. But so their hateful, homophobic words were particularly horrific for him. And he sues for sort of emotional distress and wins a multi-million-dollar verdict. And the case goes to the Supreme Court, and Chief Justice Roberts, who describes himself as a stalwart, another stalwart defender of First Amendment rights. He thinks he's the court's leading champion of First Amendment rights. And I might disagree with that, but it shows how free speech rights are embraced not only by the Brennans and the Marshalls of the past, the liberal justices of the past. They are embraced by Chief Justice Roberts. They are embraced by Elena Kagan, Justice Kagan. When she was a professor, she wrote often about free speech issues. So Justice Roberts says that, if there's a bedrock First Amendment principle, it's that we can't punish speakers for messages that we hate. And that words have power, and that words can harm us, and it's not shying away from that. Sometimes people will say, "Oh, words can't wound," but words can wound, and this certainly, the devastating effect on Albert Snyder, the father, was very real. But in order to keep the sort of marketplace of ideas going, and to keep sort of a robust discussion of ideas going about, gays in the military, gay rights, military policy, religious freedom, Justice Roberts says that even military funeral protests have to be protected. Now, that decision can be very hard for many people to take, and there are very interesting and significant critiques of that approach, but that is the court's approach right now. One unusual way in which the sort of theoretical becomes real in this case, though, is at the time Albert Snyder was devastated and said, all I wanted to do was bury my son in peace, and the Supreme Court has prevented me from doing that. But years later, relatively recently, Snyder has said that he realizes that, in his words, slightly paraphrasing, that his son died in part to protect the free speech rights of even people like the Westboro Baptist Church. So he comes around, and one of the members of the Westboro Baptist Church, who is their sort of social media guru, who had tweeted out really disgusting things after the Supreme Court verdict, she was convinced by people on Twitter to re-examine her beliefs, who did it in this very thoughtful and respectful way. And now she is an advocate for free speech. So they both flip their positions literally through the power of hearing ideas that they disagree with. So as flawed as the marketplace model may be, there are times in which the theoretical becomes real. And even, if you made it this way in a movie, it would seem too unbelievable. But these protagonists or antagonists really did both come to agree that free speech is the answer, even when it involves hate speech.
I have to ask, because this case, like all of the cases and to some degree in your book, keeps bringing me back to the idea of violence, which I may not have thought initially when I was thinking about free speech would be an issue, but it seems to be a recurring theme, either that speech does violence, there's a concern that free speech will lead to violence, or members of the public reacting violently to people expressing certain ideas. Any thoughts about why this is such a powerful and consistent theme across very different types of situations?
It's a really interesting question that I haven't been asked before, but thinking about it now, I think I sort of have two thoughts. One is the power of speech. The reason violence is so linked to speech is because speech is powerful. This goes back to what Justice Holmes was saying, that if speech was sort of impotent, if speech was sort of unimportant, then it wouldn't cause alarm. It wouldn't cause passions to sort of get heated, and it wouldn't potentially then lead to violence. So I think the connection between speech and violence is actually a testament to the power of speech, a testament in the good and bad sense. So that's one thought. The other thought I want to make clear, and I talk about this in the first chapter, because what Molly Steimer and the other anarchist defendants in the Abrams case back in 1919 were accused of, it was violating the Espionage and Sedition Act, but really what they were being accused of was incitement. And this came up, of course, I had no idea this would come up when I was writing my book, but this comes up in relationship to the attack on the Capitol and Trump's defense to the attack on the Capitol. And I do want to make it clear that there is no First Amendment defense to violence. There is no First Amendment defense to trespass or free speech defense. And that while advocacy of illegal action is protected, it is protected up to a point. And I talk about this in the first chapter. And in brief, you are allowed to advocate for illegal action up until the point when it is directed to cause imminent harm or imminent violence, and when it is likely to cause imminent violence. You need both components. So I begin that chapter by talking about how Madonna at the Women's March in 2017 said she had thought an awful lot about blowing up the White House. And in the next sentence, she says, but I've decided to choose love over hate. But Madonna would be squarely protected by the incitement test that comes out of Abrams. It's called the Brandenburg test. And because one, it wasn't directed to causing imminent violence. She said a sentence later that she chose love over hate. And two, there was no likelihood of harm. There was no time to build a bomb. There was a peaceful march. There was no violence. So there was no likelihood. With Trump, it's a much closer call. We don't need a likelihood with Trump and his rally before the Capitol attacks. We don't need to say likely imminent harm. People died as a result of that riot. And whether he was directing it is a very close call. I personally think he was, but that and that is considered a very speech protective test, which I think is a good thing. But it is not a test that always protects speech. So there are limits to when speech leads to violence. But they are intimately linked, and it's an interesting concern that you raise, and it is not one that has easy answers.
Not a lot of easy answers in many of these cases, but a lot to think about. And unfortunately, our time is close to an end, but I want to give the final question to the audience who ask, were there any free speech cases in hindsight that you wish you could have included in this book? We only touched on some of them.
Yeah. I didn't do the flag burning cases. And those are really interesting in the interplay, again, between sort of facts between Congress and the courts. That Congress kept sort of trying to create a constitutionally permissible law that would prohibit flag burning. But really, the court had said that when you're engaging in flag burning, since burning is the proper way of disposing of a flag, that when you're engaging in flag burning, what you're doing is really trying to regulate ideas. Again, the government is trying to regulate ideas, not actions, because the action is actually allowed. It's when you're doing it as part of a protest that was trying to be prohibited. So that's one case that would have been fun to include, but I felt like people don't engage it. That's less of what people need to know today. This is a less practical need for most of us to don't need to engage in flag burning. And the other really interesting case that I would have liked to talk about is the Stolen Valor Act case, where Congress tried to make it illegal to lie about having a military record if you didn't have one, or to claim that you had military awards if you didn't actually earn them. And again, the court strikes it down as violating the Constitution and violating the First Amendment. So there is implicitly a First Amendment protections even for lies, because you'll often hear people saying, well, lies can't be protected. And there are other types of ways to limit lies. You can sue for libel. In the commercial context, there can sometimes be trade regulations. But there is, in fact, a First Amendment right to lie. And the reason, sort of to simplify and wrap up quickly, the reason is who will decide? Because do we want the government involved in deciding truth? And I think, liberals and moderates over the last 4 years wouldn't have wanted the Trump administration to be deciding what is truth, and perhaps conservatives today would not want the Biden administration deciding what is truth. So those are two great cases, but I do believe that the 10 cases that I talk about will give you the tools you need to think about those type of issues whenever they come up. And sort of all of the great Supreme Court cases. This gives you a guide to understanding how cases work, and also sort of laying the groundwork for a substantive knowledge of free speech. I say that, studying the law, you learn in law school that the law is like a seamless web, and you're supposed to study every thread in order to understand how it all holds together. But I say this book is like a rug from IKEA. It's not as beautiful, but it covers what you need, and you can get it much quicker and cheaper. So I hope people will get it and learn quickly about their rights in an effective way.
It is a really engaging and beautifully written book. So congratulations, Ian. And thank you so much for joining us tonight. Thanks to all of you watching at home. And we will see you hopefully in a few weeks for a new program.
Thanks again. I hope people get the book, and I hope they buy them from the Tenement Museum. There are signed copies at the Tenement Museum gift shop.
And links in the comment below.
Great.